I please your lordship, I beg to mention for listing one rate petition lordship.
Listing for what?
Lordship in service matter lordship.
আচ্ছা that entry করবো দিও
May it please,
Much of-
please, Your Lordship. I want to withdraw an writ petition, my lord. May I pray for listing the matter tomorrow, my lord?
May please your lordship. Sir, I beg to mention for listing lordship. Matter will be listed next week matter.
What is the matter?
Matter related to pensionary benefit.
Talk to him, he'll tell you where to go.
Yes, yes.
Supplementary for withdrawal, I will take one.
Where is the council is present? Is it your matter?
21.
You want to withdraw?
Yes, petitioner
Why?
would like to pursue the case. Sir.
Huh?
He has written a letter to me. Doesn't want to pursue any.
Acha, Mr. M. Gogoi, learned counsel for the writ petitioner submits that he has received written communication dated
15/6.
15/6/2025 from his clients intimating that the petitioner does not pursue this does not want to pursue this writ petition any further. As such, submits Mr. Gogoi, the writ petition be disposed of as not pressed. Mr. R. Dhar Lanet, additional senior government advocate Assam, is present on behalf of the state. On the request of the petitioner's counsel, this matter stands disposed of as not pressed.
All right.
Daily list for motion item 1.
May please your lordship. Non-compliance of the order dated 7/8/2024 lordship.
There is no timeline given in the order.
Yes, lordship.
Then,
Lordship already Sanjita Roy and others state of versus lordship.
correct, but the order does not say within how many days it is to be complied.
Lordship. Already 10 months has gone lordship.
Take down. Heard Mr. P.K. Gogoi and counsel for the petitioner perused the statements made in the petition alleging willful disobedience of the directions contained in order dated 7/8/2024 passed by this court in WPC number 2499/2024. This contempt petition has been filed. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents by registered post office.
Highly egregious.
May His Lordship, non-compliance of order dated 18/2/2025. My Lord, whereby the Honorable Court set aside the impugned order and directed to reinstate the petitioner.
Miss T. Wapangla Diba or case number 2 Diba order dated
18/2. 18/25.
18/2/2025 WPC number 4350/2020. বাকি খিনি একে থাকিব।
Item 3.
May please, your lordship. Also,
Yes.
non-compliance of the order dated 29/1/2025, lordship. Annexure A, page number 9.
You are Mr.
PP Fugon.
PP Fugan আৰু এইটো order date টো আৰু এইটো দি দিব। Order dated 29/1/2025 or WPC number 6155/2023.
Comment.
Item 4. If it is ready and it is sent for vetting, Lordship, some more time required.
None appears for the petitioner on call on the request of Ms. S. Bowa, Linet CGC, who submits that affidavit has been prepared and the same has been sent for vetting. Let this matter be listed again after 2 weeks for motion.
Item 5. Lordship, here inquiry is conducted, it was in his favor, no copy of the inquiry report.
What has happened? The report has been given.
Lordship, we have asked for the submitting the inquiry report, but they says that he has to apply this for the inquiry report because the letter is inquiry report is confidential, Lordship. So 89 pages,
Yeah.
it's at 89 pages inquiry report. So he has to apply to the authorities or submit.
No, he will not apply. We'll stall everything. You
Then
can't come up
Lordship,
with-
I
No, no.
have the soft copy and I can submit him to your Lordship.
Huh?
I'll get the soft copy by today. In the meantime,
but
during the course of the day, I'll get the
On
soft.
13/6, this was, matter was adjourned for you to submit
Yes,
this.
we have.
Why haven't you not given?
We have asked them to submit the inquiry report to them. Now,
Why it has not been done?
they said they sent the inquiry report to Judicial Department.
Hmm.
Thereafter, on inquiry, it said that
All right, then we'll stall everything here.
I have a soft copy. I'll provide him a Lordship.
You should have done it already.
Because just now we have received that. It says it's confidential. So that's the issue we are facing. Lordship.
How can you act on a confidential inquiry report?
We're not. That's why that is sent to Judicial Department. It had been sent to the Judicial Department.
Then you don't take any action.
I'll pay it till the course of the day. We'll submit him the inquiry report. He won't have to apply, your Lordship. During the course of the day.
To apply, your lordship.
No, that's all right. We are interacting on that.
My lord.
The court is interacting.
Fine.
So we'll supply him during the course of the day, your Lordship.
No, you will supply him by 11:30.
Very well, Lordship.
Otherwise, we'll pass an order directing
Very-
some measure. Wait till 11:30.
Very well. Oblige, Lordship.
No, I'm filing the affidavit on behalf of the respondents today, madam. So we may copy. I'm filing an affidavit in reply in this matter today,
So
madam.
is there any distinction between the
No,
previous
on
case?
the face of it, there is no distinction.
Then what affidavit you want to file?
Let it come on record. Lordship will take it up on Friday, perhaps. Let it be on record. That is my only. That we are. I'll give my learned friend a copy.
All right, then we'll have it on Monday, not
Monday.
Friday.
Lordship.
23rd. Heard Mr. H. Agarwal, learned counsel for the petitioner on the request of Mr. Ganguly, who seeks 3 days time to file a short affidavit. List this case again on Monday, that is 23/6/2025, along with the affidavit, if any, filed by the respondents.
Lovely.
Who appears here?
Compassionate appointment, Lordship, died on 3/12/2009.
All right, we'll just pass over for the time being. There he is. Yes,
Lordship,
3/12/2009.
yes, okay. Thereafter, within 1 year,
Hmm.
my mother had applied. Thereafter, the respondent authority had advised that after attaining the age of majority of the petitioner to apply for the same.
But
Then
then
according-
now it is not possible. Have you challenged 18/9?
No, Lordship.
Lordship,
Listen.
No.
Have you challenged the 18/9 OM?
no, Lordship.
Then the writ petition is not maintainable.
Yes, Lordship.
Yes, then we'll dismiss it.
No, Lordship.
Take
Lordship,
10 minutes time. Either you challenge it by withdrawing or I'll dismiss it. 10 minutes.
Lordship,
Yes.
if rejected, they had not communicated.
Nothing. Now compassionate appointment matter cannot be touched. After 10 minutes, it will be called up. You make up your mind.
Issue notice whether rejected or
After
not.
10 minutes, you call it. Be here after 10 minutes. I'll pass an order. Yes.
Petitioner is paying for disability pension that was rejected because he was discharged on medical ground. So I am paying for.
But you have come very early. Huh?
Submitted many representation.
Only 20 years late.
And work for only 1 year.
Huh?
Work for only 1 year.
That will not come, my lord, 1 year, 2 year.
Why you want to give more agony to your client? Who has given him the idea that he can come to the court after 20 years seeking pension?
Some people are getting pension who have come, who are discharged in 1990 also. They are getting, as it is a.
You
pension
examine this.
matter.
There are judgments which says pension claim has to be asserted within 3 years. If the claim is granted and then payment is delayed, then it is a continuing cause of action. But the claim has to be asserted. Do you know the judgment? You don't know. Okay. In the afternoon, you take it from her, read it, and I'll give it to you also. We'll have it after vacation. Okay. But your petition cannot be accepted. But I want you to know why it cannot be accepted. This law is against you. Within 3 years of the cause of action, the claim has to be asserted in the court of law. Otherwise,
I have next one.
Huh?
Similar judgment I have next.
give me.
I have next in my petition.
Yes, give me a judgment where after 20 years pension claim has been accepted. Which page?
Next one, 7 page 22, my lord.
Huh?
Alexa 7 page 22.
Annexure?
7 page 22.
Hmm. Yes, when was he discharged from service in this case?
Medical ground, my lord.
Yes, when was he discharged?
2002.
11.
2011.
11.
And he filed the writ petition on?
Uh,
2018.
Hmm.
18.
So I don't know what is here, but he was not aware of the law. That cannot be a ground for the court to give you. He did not point it out because he was not aware. He did not read the law. What to do? Beyond 3 years, pension claim cannot be accepted. So after vacation, or you want me to pass the order today? But I'll give you the judgments. I'll find out and give you. Nowadays, the judges are doing research for the lawyers also. 1 o'clock, you take the judgment. On the request, Miss Bora, I counsel for the this case for motion again after the summer vacation. Mr. Roy,
Lordship.
sometimes do some study.
Lordship.
Huh? It seems the
Clear?
CGC is
Lordship,
only role is 2 weeks for instruction, 3 weeks for instruction. Beyond that, you don't do anything.
Lordship, that case was because his the basic training was held on this was attributable to that case, Lordship. The case, my friend NX, Lordship.
Yes, but are you not aware that pension claim cannot be asserted
Lordship,
after 3 years?
3 years. But their Lordship, her claim was made earlier, Lordship. After basic training, he was made the claim, Lordship.
He made the claim.
Lordship.
All right. So I'll give you the judgment. There are 2 Supreme Court judgments on this. You read it. If you can distinguish, then we'll consider. Yes.
My lord, the page 59, my lord, the petitioner was 53, my lord. Petitioner was placed under suspension, my lord.
Prolonged suspension, what has happened? Have you, he's saying you have not reviewed it nor extended it within 3 months.
Kindly fix the matter in the next week, Lordship. I will.
What will happen in the next week?
Lordship, what is the position, Lordship? I have to take instruction, Lordship, from the Deputy Commissioner, Lordship.
So it's an order of February. Let him obtain instruction. Heard Mr. Jay Borwell and counsel for the petitioner. The grievance expressed in this writ petition pertains to alleged prolonged suspension of the petitioner, which was allegedly extended without conducting proper review. On the request of Mr. J.K. Goswami, learned additional senior government advocate Assam, list this case again in the next week for motion so as to enable him to obtain updated instruction. Mr. R. Borpujari, learned standing counsel for
Respondent number 1, 4, and 6.
Standing Counsel for Finance Department is also present. One extra copy each of the writ petition be furnished to the learned Department Counsel. List again in the next week as a fixed item for motion.
Please. Compensation appointment letter. It's not father expired 22/7/2000. 70/2015.
So he has challenged 18/9/2024. We'll issue notice.
No.
Because this issue has not been decided by the court, whether this notification is valid or invalid. Ensure that next time there is no consent order, there is some decision on this. Yes. Lord Mr. L. Gogoi, learned counsel for the writ petitioner, peruse the statements made in the writ petition. The matter pertains to prayer for appointment on compassionate ground. The petitioner has also challenged the OM dated 18/9/2024, by means of which a complete ban has been imposed on appointments on compassionate ground. Full stop. Mr. J.K. Goswami, learned additional senior government advocate Assam, and Ms. M.D. Bora, learned standing counsel for the transfer department, are present and have prayed for some time to obtain instruction. Prayer allowed. NOM 6 weeks. Since Ms. Bora has accepted notice for respondent number 1 and 4 and Mr. Goswami for respondent numbers 2 and 3, service of notice in this case is deemed to be complete. Extra copy of the writ petition be furnished to the learned Department Counsel, requisited numbers so as to enable them to obtain instruction.
Item 11.
So this matter is regarding the appointment of Gaon Pradhan. The respondent number 4 has been appointed violating the provision of executive instruction 162 of the land and regulatory.
You have filed the appeal. Have you filed appeal?
There is total violation of the rule. That is why no need to file the appeal.
No, you are questioning the selection and appointment.
Yes, Lordship.
Please listen. Let me speak.
Sorry.
Will you permit me to speak? Please.
Sorry.
You are challenging the selection and appointment of the private respondent as Gaon Pradhan, right? You have mentioned the grounds that he does not belong to the Dhemaji revenue circle. That's one of your grounds. Have you preferred any appeal before the authority?
No, Lordship.
Why?
The provision violated by the authority is regarding the 7 of the executive instruction. Since there is a full violation of the rule, in my information, so far my knowledge, from my limited knowledge, I'm saying Lordship.
All of our knowledge is limited. You don't have to worry about it. Yes.
That is why I'm approaching directly before this tribunal.
See, Mr. Hazarika, I can issue notice.
Yes.
After 3 years, they will ask you to go to the
Appellate
authority. That means by that time he will complete his term. What do you want? Because the ground you are saying, no court will accept it.
I may be allowed to file.
That's why I'm asking. If you want time to think about it, I'll give you. Do you want to take a decision today or on Friday? Today. You want to withdraw and prefer a statutory appeal? Yes. What about the delay?
Lordship, delay may condone, Lordship. Lordship may pass the appropriate order, Lordship, regarding delay, Lordship.
Pass order in the appeal?
No, Lordship, regarding delay of filing the appeal, Lordship.
Mr. N.M. Hazarika, learned counsel for the petitioner, submits that the selection and appointment of the private respondent as Gaon Pradhan of private respondent number 4 as Gaon Pradhan of lot number 3 Dhemaji Moja under the Dhemaji revenue circle is under challenge in the present writ petition. However, since there is a provision to prefer an appeal under Rule 162 of the executive instructions framed under the Assam Land and Revenue Regulation, he be granted leave to withdraw this writ petition with liberty to prefer an appeal. Mr. Hazarika has also sought an observation from this court to the effect that the delay in preferring the appeal be condoned after taking note of explanations furnished by the petitioner stroke appellant in that regard. Mr. J.K. Goswami, learned additional government advocate Assam, and Mr. S. Datta, learned standing counsel for the Revenue Department Assam, are present and do not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for. You give your explanation why there was delay.
Item 12.
May please, your Lordship. Lordship, here, this matter already, my Lord, that there is an appeal against this impugned office memorandum before the division bench. But in this matter, similar order has been filed by coordinate bench of this court. That is at page number 119. Lordship, same issues in this another department.
But what is the issue?
Lordship. Lordship, I was an assistant executive engineer. Thereafter, I was promoted. Lordship, we have to look at page number.
No, we'll come to the page now. What is the issue? Tell me now.
Lordship, the issue is that, Lordship, I was downgraded in my seniority in the cadre list of the additional chief engineer. Prior to that, Lordship, these
when did it happen? When were you downgraded?
My Lord, this was the impugned gradation list is at page number 81, Lordships.
I have asked when were you downgraded? You are saying page number 18?
Lordship, in the
when were you downgraded?
In the last gradation list, provisional gradation.
When were you downgraded? What is the date?
Lordship, 22nd of November 2024.
So I need to ask you this question 4 times to give that answer.
Extremely.
24,
Lordship, 22nd November 2024.
Yes.
Thereafter, Lordships, objections were called for. I filed an objection that I cannot be downgraded because I have got this seniority in terms of the consequential seniority of the office memorandum. Thereafter, Lordship, they cite an example of the another department saying that these has already been occasioned to various departments in terms of the office impugned, present impugned of office memorandum of 18/1/2023. They say that now we have brought in the principle of catch-up. Lordship, the issue arises.
That's another thing. Now,
Lordship.
what has happened? Then final list has been published.
Final list
When?
Lordship, that has been prepared on 5th of May 2024, 25 Lordship. 5/5/2024. That is impugned order.
So you are challenging this.
We are challenging and the impugned speaking order.
Which page is speaking order?
Lordship, that is at page number 90.
90.
90, Lordships.
Yes.
Lordship, these respondents 1 to 9, Lordships.
Hmm.
Their date of promotion as additional chief engineer, Lordship, you'll see at column number 5.
Hmm.
These are all on 13/8/2024 till number 8. And in respect of number 9, it is 2023. Lordship, my date of promotion is 25/1/2023 down below, Lordship, at serial number 10. These persons, my lord, do not have the qualifying service. Lordship, I'll produce the relevant qualifying service. Is it? Is it? For the post of additional chief engineer to the post of chief engineer has to be 2 years, Lordship. That is a gazetted notification, Lordship. Page. Lordships.
Yes.
The second page, Lordship, down below additional chief engineer has to be 2 years. Well, they have not completed their qualifying service if they have been promoted to the rank of additional chief engineer in the year 2024. So for the post of chief engineer.
All right. So what is the order you are seeking right now?
Lordship, I'm seeking, Lordship, a similar order has been passed in this matter, Lordship. That is at page 119. Lordship has seen that in that order, Lordship, the court has categorically held that if they don't qualify for the qualifying service, they shall not be allowed to promoted to the next rank of chief engineer. Now, Lordship, the issue is that they are about to call for the selection board meeting and promote these two persons out of this 8 persons to the rank of chief engineer. 119, my lord. But the relevant portion is at page number 99, 127, Lordships. Para number 16.
This is in the same department.
Lordship, this is in public health department. There also, Lordship, the qualifying service was not there. 18(1) office memorandum has been challenged. That is not in consonance with Journal Singh 2 of the Supreme Court, Lordship. I'll just demonstrate that 2 paragraphs of Journal Singh 2, the department on which they are acting upon is not in consonance with Journal Singh 2. Journal Singh 2. This one. Yes. Yeah.
So you are saying the private respondents are not eligible to be promoted as additional chief engineer?
Well, the next post is of chief engineer. Their Lordship 2 years service is required. Prior to this, Lordship, superintending engineer also is 5 years. That also they do not qualify. They've just been promoted above me on the basis of a group service. Group service has been deprecated in this judgment of Supreme Court, Lordship. They said that it cannot be group wise, it has to be cadre wise. Seniority always has to be cadre. That is the short part. But shall I take my lords to 18/1/2024 judgment office memorandum, where Lordship the impugned clause has been invoked. That is at page 170 for my lords. Lordship, the judgment's office memorandum starts at page 116. The relevant clause which I'm challenging is 4A, Lordships.
Yes.
In case of promotion in Group A services, the quantum of reservation for SC STP in promotion shall be as per stipulated percentage of reservation available for these categories. However, SC or STP or STH government services in Group A, services on their accelerated promotion by virtue of rule of reservation shall not be entitled to consequential seniority. The application of general catch-up will allow eligible officers who were senior in the merit list at the entry level in Group A services to regain their seniority in the promotional course once they are promoted to the same cadre as an officer of reserve category, provided officer of the reserve category has got its promotion ahead of an officer senior to him in the merit list by way of accelerated promotion on account of reservation in promotion in a particular cadre. Seniority of government servants in Group A service shall be revised accordingly as per the above principle. The Lords may take the judgment of the Supreme Court at para number 66. This is Supreme Court's 2022 10 SCC 595.
Para number?
Lordship, para 66, page 31. Lordships.
Yes.
Lordship, para 67. I'll start. Lord.
Hmm.
Collection of quantifiable data for determining the inadequacy of representation of FC and ST is a basic requirement for providing reservation in promotion as laid down by the court in M. Nagraj. The unit for the purpose of collection of data is cadre, Lordships. According to M. Nagraj and Journal Singh, for the purpose of collection of quantifiable data for providing reservation in promotion, the entire service cannot be taken as a unit and treated as a cadre, as already stated. The structure of service in state of Karnataka is along with the same lines as that of services in the central government. Services are divided into groups which are further bifurcated into cadres. There is no confusion that a cadre is not a synonymous with a group. The first term of reference of the Ratnaprabha Committee was to collect data cadre-wise. The conclusion of this court in B.K. Pavitra that the expression cadre has no fixed meaning in service jurisprudence is contrary to the judgments of this court, which has been referred to above while answering point number 2. In clear terms, M. Nagraj has held that the unit of collection of quantifiable data is cadre and not services, as has been held in B.K. Pavitra. Article 16(4) of the Constitution enables the state to make reservation in promotion for SC and STs which are not adequately represented in the services of the state. However, the provision of the reservation in matters of promotion is with reference to class or classes of posts in the services under the state. That groups consist of cadre is a fact which was taken into consideration by this court in B.K. Pavitra. The conclusion that the collection of data on the basis of group is valid is contrary to the decisions of this court in M. Nagraj and Journal Singh 2. The state should justify reservation in promotion with respect to the cadre to which promotion is made. Taking into account the data pertaining to group, which would be an amalgamation of certain cadres in the service, would not give the correct picture of the inadequacy of representation of the SCs and STs in the cadres in relation to which reservation in promotion is sought to be made. Rosters are prepared cadre-wise and not group-wise. Sampling method which was adopted by the Ratnaprabha might be a statistical formula appropriated for collection of data. However, for the purpose of collection of quantifiable data to assess representation of SCs and STs for the group of providing reservation in promotion, cadre which is not a part of a group is the unit and the data has to be collected with respect to each cadre. Therefore, we hold that the conclusion of court in B.K. Pavitra approving the collection of data on the basis of group and not called cadres is contrary to the law laid down by the court in M. Nagraj and Journal Singh. But if this ought not to have been collected in terms of groups, that is what the clause 4 has been put. Well, what has happened? Let's see.
Where is 18-1-2023 OM?
That is also at page 117, which my lord has just seen. Page 117.
This has already been upheld.
Lordship?
This OM was challenged and it has been upheld.
Single judge has already upheld. Then the
Do you have the judgment of the single judge?
Yes, Lordship. Lordship, there Journal Singh 2 was not discussed. That is the. Lordship, it starts from. Lordship, it starts from page 94. Radheshwar Lankasa, fifth number judgment, Lordship.
Yes. Yes, Mr. Naik, you are appearing?
Yes.
Yes, what is the stand?
So far as this OM of 2023 is concerned, Lordship, if Lordship comes to page 117, Lordship.
Hmm.
Page 117, that
Yes.
is small Roman 4.
Hmm.
If Lordship comes to the last two lines of that paragraph, Lordship.
Hmm. Yes.
Seniority of the government servants in Group A services shall be revised accordingly as per above principle. So thereafter, Lordship, seniority list of all the departments have been revised, and on that basis, Lordship, promotions has been considered. That is one, Lordship. This is not in respect of irrigation department only, in respect of all the departments. And so far as Lordship, this gradation list is concerned, Lordship, if Lordship comes to the same gradation list, Lordship, at page 90.
No, but just a minute, Mr. Betala, you have a problem. Leaving aside the merit part of it, the learned single judge has already upheld 18-1.
Lordship.
And this downgrading is pursuant to 18-1/2023. You can't, how can this court stay it now?
Lordship, the thing is that. Lordship,
You have to prefer with leave, you have to prefer a writ appeal against the judgment.
Lordship, then Lordship, only thing is that in that case, Journal Singh 2 was not preferred, Lordship. And Journal 2 categorically says group-wise service cannot be. It is contrary to two judgments. So
No, that's not the point. Point is, whatever be the reason, the OM has been upheld.
Oh, absolutely.
See, otherwise, every judgment you will say that para was not discussed, so this is bad. Once the coordinate bench has upheld it,
Lordship.
only a higher superior court can interfere with it.
Correctly, Lord, there is another coordinate bench, Lordship, which has already dealt with same aspect, Lordship. That is at 119, Lordship. That court says that, Lordship.
But that is an interim order.
That is an interim order, Lordship. But the court has.
The other one is a final order.
That is the final order, Lordship. But here, Lordship, in 119, which Lordship has dealt, Lordship, there are two other aspects also, Lordship. That is the department rules are also not enforced. The qualifying service this person has to have, Lordship has.
No, these are good grounds. But this is not a ground to ignore a coordinate bench judgment.
Well, that is absolute, my Lord.
So what to do now? You tell me.
Lordship, since.
We'll have to do what is legally permissible. I may be convinced with your arguments to some extent. But now a coordinate bench has upheld, affirmed the notification. And they have acted in terms of the notification. Staying that means I'll stay the judgment of the coordinate bench. That's why it cannot be done. What do you want? Notice to be issued?
Lordship, let notice go on, Lordship. And Lordship, that observation of this similar judgment of
there can't be any interim relief.
Lordship, that would be, Lordship, then they will proceed. And there is one more judgment I've just pleased, Lordship. That seniority has to be categorized. That is also of the Supreme Court, Lordship.
Mr. Betala, you simple communication, you understand it. I am asking you, what relief are you seeking? If it is only notice, then we can issue notice. Let them file their reply. But you can't get any interim order here.
Lordship, in that case, Lordship, if they proceed with the.
They will. You have to challenge that single judge's order with leave before the division bench. Because their entire action is based on 23 notification.
23.
And that has been affirmed.
Affirmed by this.
Once the court affirms, it's affirmed.
Correctly.
The same, you see, coordinate benches cannot take digressive views.
Correctly, Lord. But since another coordinate bench is there, and prior to this, Lordship, the basis of this 18-123.
So it seems you will go on saying the same thing again and again and again.
Lord.
What do I do?
I'll leave to my Lord's discretion.
Then I'll dismiss it. Why aren't you answering the questions of the court? Do you want a notice? If yes, I can issue a notice. Otherwise, anything more than that cannot be granted. Then you have to withdraw and prefer a appeal with leave.
So, Lordship,
if you have urgency,
Lordship, we have urgency, Lordship, because they will be conducting the selection committee and the.
Then you withdraw and prefer a. I can only say that this matter is covered under the judgments. Therefore, granting leave. Granting leave to the petitioner to prefer appeal will close this writ petition.
Then we'll direct
that I can give. You have to say something which is possible. Don't go on saying something which makes no sense. That will give him. Yes, Mr. Naik.
Lordship, there is already an appeal. We may connect with that appeal then.
That is your. Let him pursue an appeal if he wants. Yes, because this is issued under OM so and so, which is upheld.
Yes, that is nice.
Therefore, there is no scope for this court to take a divergent view.
Yes.
We'll decline, but grant him Leave to prefer an appeal if so advised.
Lords will indicate that this is covered by Janit Singh too, Lordship.
No, Lordship will not.
That you take it.
For that, you will have to go to that bench, Lordship, which have decided the matter.
That's why I'm saying you prefer an appeal. Appellate court can look into everything.
We'll look into it.
Heard Mr. H. Petala, learned counsel for the writ petitioner. Also heard Mr. P. Nayak, learned additional AG Assam, appearing for the respondent numbers.
All lots.
All assisted by Mr. J.
1 to 5, 1 to 4,
Learned additional
5 to 13 are private response.
senior government advocate Assam, appearing for respondent numbers 1 to 4. The writ petitioner herein, who is serving as an additional chief engineer in the
Irrigation
Department, Assam, has approached this court inter alia, challenging the gradation list published on 5/5/2025, as well as the consequential order dated 5/5/2025, by means of which his seniority position in the cadre of additional chief engineer has been downgraded so as to place him below the private respondents. Full stop. It appears that the impugned notification has been issued by relying upon OM dated
18/1/2023 at page number
18/1/2023,
116.
issued by the Government of Assam, Department of Personnel, Dispur. Full stop. Mr. Betala submits that, Mr. Betala submits that as per the decision, you write like this. It appears that the OM dated 18/1/2023, which was put to challenge in WPC number 6386 of 2024. What is the WPC number?
Lordship. 363. 363 of 2023.
(363/2023). Bracket Radheshwar Langthasa versus State of Assam and others, bracket closed, has already been affirmed by a coordinate bench of this court by the judgment and order dated 4/6/2024. Full stop. Full stop. Mr. Betala submits that the judgment rendered in the case of Langthasa Supra Nam to Didibasu was not, after considering the law laid down by the Supreme Court in the case of Jarnail Singh and others versus Lakshmi Narayan Gupta and others, reported in 2022, bracket close 10 SCC 595, wherein it has been categorically laid down that the reservation roster is required to be applied cadre-wise. Is that
Lordship,
your?
the last part of therefore we hold that the conclusion in BK for approving the category just above para 70, Lordships. The last 3 lines, we hold that the conclusion of this court in BK for approving the collection of data on the basis of group and not cadres is contrary to the law laid down by
Laying down that collection of data for applying the reservation roster is to be done on the basis of cadre within court's cadre and not on the basis of groups within court groups, has not been not on the basis of groups. Therefore, the said decision is a judgment rendered per inquirium, the decision of the Supreme Court. Full stop. Mr. Betala has also relied upon and referred to the order dated 18/12/2024, passed by another coordinate bench in WPC number 6386/2024, wherein the action taken by the department in the action taken by the health department in terms of the OM dated 18/1/2023 has been deprecated. First up, however, the order dated so-and-so 18/12/2024 is an interim order, whereas the judgment and order dated 4/6/2024 affirming the OM dated 18/1/2023 is a final order, bringing the proceeding itself to its logical end. First up, under such circumstances, until and unless the judgment and order passed in the case of Langtasa is set aside and or modified by a larger bench, this court, the law laid down therein will be binding upon this court. In such circumstances, in view of the above, the prayer made by the petitioner in the present writ petition cannot be, particularly for issuance of an order of an interim order, cannot be accepted by this court. At this stage, Mr. Betala seeks leave of this court to prefer an appeal against the judgment and order dated so-and-so in Langtasa, granting leave to the petitioner to prefer appeal as prayed for. This writ petition stands closed.
I'm deeply.
You prefer an appeal and get appeal. There's no point.
Correctly, my lord.
There will be hundreds of technical problems here.
I do it. I'm deeply blessed.
May I please, Your Lordship? Hearing your Lordship, the petitioner is a physically disabled person suffering from 60% orthopedic, Your Lordship. And by annexure number 4, order dated 2/4/25, he was transferred from Badalpur Sibhumi to Golaghat, which is about 1,000 kilometer away, Your Lordship. Now, there is a judgment from the Honorable Supreme Court, Netram Yadav, Your Lordship, wherein to mitigate the disadvantage faced by the disabled person, it was made as far as feasible, the disabled person should be placed at where they could, their movement could be free.
Yeah, who's appearing?
On behalf of Estata, Lordship. Lordship, notice may be issued.
Your Lordship, it is the second round of litigation. On the first one, Your Lordship may kindly.
What do you want? The petition should be allowed today?
No,
Then no notice should be issued.
not what I'm saying, Your Lordship.
What do you want? You have three options.
Yes.
The petition can be dismissed today. That is no notice. Petition can be allowed today itself, or notice can be issued. Which can be which?
Let notice be issued, Your
That's what
Lordship.
she's saying.
But the relief order, Your Lordship, in the first round of litigation, this Honorable Court directed the Commissioner to dispose of shall dispose of the represent within a period of 20 days. Now, while that is pending, Your Lordship, the subordinate BDO has relieved me. That's why I am before this Honorable Court, Your Lordship.
So then,
notice may go, Your Lordship.
Then you tell us next week why you have relieved when there is an order of the court.
Yes, Annexure page 8, Annexure 8, page 46, relevant is as 48, Your Lordship. Your Lordship will kindly see. 48, the last paragraph. While not interfering with the impugned order dated so-and-so, considering the petition as filed a represent before the Commissioner PNRD for reconsideration of his transfer from Badalpur Chaitanya Nagar, Anchalik Panchayat under Sibhumi, Jila Parishad to Golaghat by order dated so-and-so. It is provided that the respondent authorities, particularly the Commissioner PNRD, shall consider and dispose of by represent within a period of 20 days from today. Now, Your Lordship, the impugned order 10, page 55, last page. While this is pending, Your Lordship, the subordinate BDO.
Page?
Page 55, last page, Your Lordship.
Yes.
Now, in pursuance of the above referred order, that is the transfer order of the commissioner, the C so and so attached to Badarpur is hereby relieved from his duty this afternoon, so and so.
So what has happened to the representation?
Nothing, no
I may be
communication.
giving proper instruction of next week.
All right. Heard Mr. R. Majumdar and counsel for the writ petitioner peruse the statements made in the writ petition. The petitioner claims to be a person suffering from 60% disability. Bracket orthopedic. Full stop. While discharging his duty, he was serving as what?
Senior assistant, it is a promotional transfer, Your Lordship. Even I am ready to forgo my promotion. I am ready to forgo.
Discharging his duties as senior assistant under the Badarpur Chaitanya Nagar Anchalik Panchayat, coming under this Sribhumi Jila. The petitioner was transferred to Golaghat Jila Parishad by the order dated 5/4/2025. Aggrieved by the impugned order of transfer dated 5/4/2025, the petitioner had earlier approached this court by filing WPC number 2053/2025, which was disposed of by the learned single judge by order dated 11/4/2025, by providing that the representation submitted by the petitioner before the Commissioner of PNRD Department Assam be disposed of within a period of 20 days. Full stop. The grievance of the petitioner is that without disposing of his representation submitted against the transfer order, the block development officer of Badarpur Chaitanya Nagar Development Block has issued the order dated 13/6/2025, relieving the petitioner from his present duty. Mr. Majumdar submits that the personal difficulties faced by his clients are to such an extent that he is even willing to forego his promotion if the transfer order is stayed. Full stop. The learned standing counsel for the PNRD department could not appraise this court as to whether the representation submitted by the petitioner has been disposed of in the meantime in compliance with the order dated 11/4/2025. Under such circumstances and as paid for by the learned counsel, learned departmental counsel, this writ petition is directed to be listed again on 26th of June 2025 so as to enable the learned standing counsel PNRD Assam to obtain instruction and appraise this court as to whether the representation submitted by the petitioner has in the meantime been disposed of, and if so, a copy of the order passed therein be produced before the court. Till the next date fixed, status quo as regards the place of posting of the petitioner at Chaitanya Nagar so and so be maintained. Two extra copies of the writ petition be furnished to the learned department counsel.
Much of it.
Regarding transfer, my lord, I was, my lord, within 9 months from my earlier posting and transferred, my lord, again. That is annexure 2, my lord, is my transfer order. My earlier transfer order was, my lord, I earlier was my promotion and transfer. That was in, my lord, 13 August 2024. Now, my lord, within 10 months, almost 9 months complete, my lord. On 10 June 2025, annexure 2, my lord. Again, I has been transferred, my lord. So, yes, it can be done, my lord. Yes, circular I have annexed, my lord. But with proper reasoning, my lord, recording proper reasoning and placed before the chief minister, and then if it, my lord, approved, then, my lord, it can be done. But here in this case, my lord, so far my knowledge goes, my lord, no proper reasoning. Your lordship kindly see annexure 3, my lord. It is a circular, my lord. Very clearly, but before the normal tenure, you can transfer. But you have to give me proper reasoning and place before the. And why it will place before the chief minister, my lord, it has to be recorded there. So if it is completed, my lord, the record may be produced, my lord, I have no case. page 23, my lord. First one. So then another
So he is presently posted as
additional chief engineer, my lord.
Hmm.
Additional chief engineer, relation implementation, minor and micro.
Page 21,
irrigation,
lord.
Page 21, my lord.
When was he posted in this?
I posted, my lord, that is on, my lord, 13 August 2024.
And before that, he was working where? Outside Guwahati.
He was in Silchar, my lord. From Silchar to Guwahati. Then now Guwahati to, my lord,
Where is that order?
my lord, earlier one.
Yes, yes.
That is annexure A1, page 18, my lord. Page 18. Serial number 8, my lord.
The proportional order.
Serial number 8. Bimal Chandra Kolita.
Lordship, as per our verbal instruction, Lordship, the approval of the chief minister is there, Lordship. So my senior colleague has said, Lordship, that submitted the annexure for the order, wherein, Lordship, the chief minister has to accept the approval and the department has to give proper reasoning why he has been transferred, Lordship. Unless and until there is proper reasoning, Lordship, the Honorable Chief Minister cannot, Lordship, give approval, Lordship. This is my submission, Lordship. Then
Show us the record.
I'll show the record, Lordship.
When?
Tomorrow, Lordship.
No, that will be not.
Oh, already.
My lord.
Day after tomorrow.
Lordship.
Day after tomorrow.
Lordship.
Day after tomorrow.
Till then, status quo as
My lord.
for the petition.
They are not moving, Lordship. There
My
is no.
lord, they are not moving because, my lord, to go to the NC Hill, there is a permission required, and come out from the NC Hill, there is a permission required. So that will always taking time, my lord. Because my incumbent, who is coming to my place, my lord, he is not in the
Day after tomorrow, then let him produce the
Lordship.
record.
My lord.
Lordship.
We'll have it for motion day after tomorrow. Heard Mr. T.J. Mahanta, Learned Senior Counsel, assisted by Mr. D. Mahanta, appearing for the writ petitioner. Peruse the statements made in the writ petition, assailing the impugn order of transfer dated 10/6/2025, by means of which the writ petitioner, who is presently posted as additional chief engineer, implementation, minor and micro, close, irrigation, Assam, Chanmari, Guwahati, you'll get it in page 21, was transferred and posted as additional chief engineer, CHD, irrigation, NCHSC Haflong, has been assailed in this writ petition, urging that it is a case of frequent transfer carried out in contravention of the government circular, which requires approval permission of the Chief Minister Assam for implementing proposals of mid-term transfer, premature transfer.
With proper reasoning, my lord.
Mr. Mahanta submits that premature transfer can be effected only if there is approval of the Chief Minister with proper reasoning. Only when there is a proposal with proper reasoning placed before the highest executive of the state. First up, Mr. Upadhyay, Learned Standing Council Irrigation, prays for time till next Friday, give the date to produce the departmental record so as to meet the allegation made in the writ petition. Prayer allow office to list the matter again for motion on give the date 20th, not 26. 206/2000. One extra copy of the writ petition be furnished to Mr. Upadhyay. Status quo as regard the posting of the petitioner be
Probably may
maintained
not
till
be
the next-
required, Lordship.
All right.
Lord.
Till the next date.
Lordship, before my learned senior start, my lord, no writ petition copy has been served to me, though I have the standing counsel of the WMD department. Just now I have been informed by my learned senior, my lord, that this matter.
Mr. Chaudhary,
That's right, my lord. I will have to sign.
You something
Otherwise, my lord,
important?
I will, my only prayer for issue notice today. Only. And this is just more than that I cannot.
no, let her have the
I will
copy.
supply.
We'll have it next week.
My lord.
Yes.
My lord,
Next week?
I will supply it right now, my lord, let it be tomorrow, my lord.
Tomorrow is not possible.
Day
Why?
after, day after.
Why you are going out somewhere?
I am serious.
Huh?
Day after tomorrow.
Acha. Miss MD Bora Lanet, Standing Counsel for
WMD Department.
WMD Department submits that WMD Welfare of Minorities and Development Department submits that no copy of the writ petition has been furnished to her. In view of the above, let this matter be listed again day after tomorrow for motion. A copy of the writ petition be furnished to Mr. Bora during the course of the day.
I'm so deeply. Lordship, SCWMD may be reflected in the cause this.
List the matter by reflecting the name of Planet SCWMB in the cause list.
I'm so deeply.
May I please, your Lord?
Yes.
Lord, basically, my lord, I was appointed as a surveillance worker in a, my lord, Hammar Manikpur sub-center, my lord. Subsequently, my lord, my service had been, my lord, attached in Hatimura State Dispensary, my lord, for the shortage of staff at the said center, my lord. Now, my lord, suddenly they have come up with an, my lord, impugn order, by which, my lord, I have been directed to go and join in my original place of posting, my lord. My lord, the grievance is very limited, my lord. Only on health ground, my lord, I am seeking my lordship's interference, my lord, that I should be allowed.
What is your ailment?
My lord, ailment is, my lord, basically spondylitis and some neuro disorders in my back, my lord. That's the problem. There is a and still I am undergoing treatment at, my lord, Apollo in Chennai, my lord.
There are so many people, including judges, who are suffering from spondylitis. Some of them are under order of transfer also.
My lord, I know.
If you have a good principle, then it can be applied everywhere.
My lord.
Can spondylitis be ground for interfering with the order of transfer?
So actually, it is not a transfer, my lord. They are basically asking me to go and join in my original place, my lord, which is around 30 kilometers from present place.
You don't want to go. You don't like your original place.
My lord.
Huh?
My lord,
develop liking for the place.
Lord, may I make a representation, my lord, that can be disposed of, my lord. Till then,
My lord, Para 11 says it is, my lord, 15 kilometers, 25 kilometers from his residence to the where he is now being transferred. Or in fact, his original place of posting. They have stated in the affidavit.
My lord.
Why do you want to? Why are you resisting your
No, my lord,
original place
my
of
lord,
posting?
I submitted fairly and I'll go down before my lordships, my lord. It is very difficult, my lord, to interfere with such kind of, but my lord, when I have personally interact, my lord, yes, even he cannot sit properly also, my lord. That is the difficulty, my lord.
No, but where is the medical certificate?
My lord, medical certificates, my lord, we have annexed, but it is not very, my lord, may kindly turn page 26 onwards, my lord, we have the entire medical history details is there, my lord.
No, but there has to be a proper
certificate, my lord.
certificate from a Sarkari doctor that
my lord, yes.
you cannot undertake travel.
Undertake travel.
Where is that certificate?
That is not here, my lord. That is not here.
Then what is the basis on which the court will?
That's why, my lord, my prayer is very limited, my lord. I know, my lord, that this is very difficult.
Okay.
But they can, my lord, consider my representation. They can reject it also, my lord, if I cannot satisfy them, my lord. Till then, my lord, if
nobody is stopping the petitioner from filing a representation. In fact, he has not filed yet.
No, I have not
This is a
filed
prayer
it.
made today, my lord, where lordship has, my lord, sought for this information.
My lord.
Why he wants to challenge it. There is no bar, my lord, for him to challenge it. Only thing, my lord, he will not pray for any stay, my lord, that till the date it should be, not be.
No, my lord. I will file it by tomorrow, my lord.
It's up to him, my lord.
Within 10 days or 20 days, they can dispose of.
Why don't you withdraw and file?
Yes.
My lord, the petitioner is, my learned friend tell me that he is also undergoing treatment at Chennai right now, my lord. That's why some difficulty is there, my lord.
So, therefore, you see, these are not facts before the court.
Yes, my lord.
You file it, your representation, withdraw and file. Let the court not give any opinion.
My lord.
And mention these things that he is under treatment and all.
My lord.
And if they don't consider, then if you come to court, you will have something to say. Right now, you are not having anything to say.
My lord can dispose
because it is not there. Is it mentioned that he is in Chennai?
No, my lord. In page. Pera, pata.
Either we can consider a prayer to give you 3 weeks time to join. In that case, no representation. Or you have to withdraw and file representation making those statements because these are not in the record.
That is correct, my lord.
What do you want to do?
My lord, I'll file a representation, my lord, and that they will dispose of within 3 weeks or 10 days, my lord, whatever time they require, my lord. Until then, my lord.
Till then will be a problem
If
because
he's in Chennai, he will be on, of course, he will be on leave, my lord. If he's in Chennai. If he's in Chennai for treatment, he will be on leave, my lord. So question of staying doesn't arise. Automatically on leave. No idea.
Mr. Bhuya, you practically don't have any case. You are not being transferred. Your original contract
Yes,
appointment
it is not a transfer, my lord. I have.
It's not that you don't like to go there.
My lord.
These things cannot be helped by the court.
My lord.
You don't like that place anymore. That's your case.
No, my lord, I like the place, my lord, because I was originally posted. Even my attachment is a reason, my lord. Just for a moment, I want to draw my lordship's attention to that part, my lord. The my lord, page 22, annex of 5, my lord. If my lord, at the right hand column, why it was justified, my lord, my attachment in the present place, my lord, is the reason is that, my lord, there was no surveillance worker. The ground level and many populations are there, is required to be looked after. Public interest was also involved, my lord, therein, regarding my shifting.
You have not been relieved. There is no question of any release.
No, I have not been relieved, my lord. Only my services has been attached in this Harimura, my lord.
That's correct.
My lord.
Now, the impugn order.
My lord.
Where is the impugn order?
Impugn order is at page 25, my lord.
Page 25.
My lord, Sri so-and-so, now working in so-and-so, is hereby directed to attend his duties in his original place of posting at so-and-so, under Mornoy, my lord. And the order of attachment, my
You
lord.
have not carried out the direction. You file a representation. Tell them why you cannot.
My lord.
If the representation was already there, we could have given.
Yes, that is
You have
correct.
not even
No,
filed.
it is
But
not.
we say,
My-
Bhuya Council for the writ petitioner. This petition is preferred against the order dated 35/2025, by means of which the petitioner has been directed to attend duties in his original place of posting at Khamkar, Manikpur, HWC.
Khamar, my lord.
It is Khamar, yes. Khamar, Manikpur, HWC under Mornoi BPHC with immediate effect. Mr. Bhuya submits that his client is suffering from several medical problems, as a result of which who is presently undergoing treatment at Apollo Hospital at Chennai. Under such circumstances, it will be extremely difficult for the petitioner to return back to his original place of posting. Mr. Bhuya has, however, submitted in his usual fairness that the petitioner has not approached the authorities by filing any representation ventilating his grievance in the matter. Full stop. Mr. B. Gogoi, learned additional AG, bracket health, bracket close, Assam, submits that if the petitioner files a representation with proper supporting documents, the authorities will certainly look into the matter. In view of the above and by taking note of the submissions made by learned counsel for both the sides, and on the request of Mr. Bhuya, this writ petition is disposed of by granting liberty to the petitioner to submit appropriate representation before the authorities, supported by necessary medical documents. If such representation is submitted by the petitioner within 3 days from today, the same be considered sympathetically and appropriate order be passed therein in accordance with law.
Highly obliged.
With pleasure, lordship. Here the petitioner, he's seeking promotion to labor inspector from senior assistant. He's currently working as a senior assistant in the labor commissioner office. The petitioner has preferred this petition on the basis of the Honorable High Court's order, judgment and order, which was passed by this Honorable Court on last occasion, on previous occasions. That was on 27/1/2025. This Honorable Court was pleased to pass an order where the petitioner was given the opportunity by directing the authorities to consider his representation, which he was seeking for. He wanted to make a representation regarding the age relaxation because of the fact that now, as per the new amendment rules in the Assam Labor Service Rules, that consideration of age for promotion to labor inspector is considered to be 45 years on 1st of January on the year of promotion and rendering of 10 years of service. Now, this particular petitioner, he has rendered 10 years of service. He was appointed as junior assistant. But when he was appointed, his age was 37. So now that is his only problem, is that since all the other candidates which were above that 45 years age mark, they have been already considered by virtue of the preferring the writ petitions here in this honorable court. Kindly peruse to page number 69. We are directly going to the operation part of the order, which was passed by this honorable court. Page number 69.
Yes.
And the 71 is page number 71 and the operation part, my lord. In view of the above and agreed by the learned counsel for the parties, this writ petition is being disposed of at this stage of motion. Hearing by granting 3 weeks time to the petitioner to submit appropriate representation seeking relaxation of upper age limit. If such representation is submitted by the petitioner, the same is to be considered objectively and be disposed of by a reasoned order within a further period of 3 weeks thereafter. So on the basis of this, now since he probably was in the line of preferring this writ petition on earlier occasion, but the fact was that since this matter was taken up by the committee, there was a ministerial staff committee, the president and the secretary had taken up this matter, and on the basis of that particular committee, they had submitted a representation through the labor commissioner to the secretary to the government of Assam, stating on 23/1/2025, stating that the amendment which was passed in the year 2007 is a little bit against the natural justice, principles of natural justice for those employees in the Assam Labor Service. Because in 2000 and similarly in direct employment in the Assam Employment Service Rules, this was a strike off. This particular provision of strike off.
Who is appearing for the department?
So in this case itself, if our lordship directs the these authorities to consider the representation, that is that much only. We want to submit a representation with the appropriate documents, and at the same time to be considered.
You have not submitted representation.
No, that is the so that is.
Then you have to withdraw and submit it. Then we can say that the authority will consider.
No, on the basis of these particular orders, we want to submit a representation. That is our prayer. Because on similarly situated facts of similarly situated candidates, this order was placed.
Then you tell us, you get your preliminary instruction.
Lordship.
Let him will dispose it of at motion stage next week.
On short date, my lord.
Yes. Third, Mr. W. Medin and counsel with the petitioner peruse the amendments made in the petition. The petitioner is aggrieved on account of the fact that having crossed the age bar of 45 years, the authorities are not considering his case for promotion to the post of labor inspector. Although similarly situated candidates in the past have been given age relaxation and considered sympathetically. Mr. J.K. Goswami, learned additional senior government advocate Assam, prays for a week's time to seek preliminary instruction facilitating disposal of the writ petition at this stage of motion hearing. Prayer is allowed. 2 extra copies of the writ petition be furnished to Mr. Goswami. Office to list this case for motion again in the next week as a fixed date. As a fixed date.
Yeah.
As a fixed item. So as to enable the learned additional senior government advocate Assam to obtain instruction.
Oblige.
Call that matter 11:30.
Item 5.
Is it allowed?
My client didn't receive any inquiry report. Just now, my learned friend has informed me, he has sent me over WhatsApp just now. Whether it amounted to a furnishing copy of the inquiry.
Ms. Bhuya,
Lordship.
if the report is there, you examine it. Whatever order is to be passed will pass.
My lord.
But if they have given you a copy, you go through it and then tell us what is
We
to
are
be
also
done.
against the lordship issuing further inquiry against me, my lord, without serving any notice in violation of ECR judgment, my lord. No copy of the
So you
inquiry
do not want to even look into the report they have given you.
I have not.
My lord, I have WhatsApp. This file was sent to judicial.
Hmm.
At 11 today, I took out a copy from judicial and soft copy has been handed over. I have forwarded a soft copy to the council, my lords. The petitioner will be provided. Hard copy will take some time. But the soft copy has been given to the
But then you
petitioner's council.
you take 2 months time.
No, we'll give, my lord. This file was.
Why don't you take 2 months time? But you can't proceed in the meantime.
No, my lord, I have given the copy.
Hmm.
The prayer here is, my lord, lordship, the prayer. And paragraph 14, my lord. Well, in that case, lordship will issue some notice, my lord.
Just a minute, just a minute.
It will stay where it is, right? It will stay where it is.
Discipline obedience.
So the disciplinary authority has disagreed with the finding of the inquiry
Yes.
officer.
And suspension order, which is being assailed, it is already stayed by the court.
Correct.
We are
No,
reinstating him.
that's another matter. Now, the law is that if you want to disagree, you have to give a prior notice to the concerned delinquent. That's the law.
My lords,
If you have not done it, you cannot proceed further.
my lords.
Then how can you proceed with the inquiry? That's what she's asking.
My lord, since I have furnished the inquiry report, I have also asked my clients, the department, to follow the rules and provide whatever is missing there. We will be proceeding.
Right. So
with the
let
laws.
them follow, let them formally serve a copy
My lord.
and give an opportunity of being.
Yes, that will be done.
That notice has to be served that
That
for
will be-
this reason we want to disagree.
My lords.
What do you have to say?
Yes,
After the reply comes, then it is up to the disciplinary authority.
my lords.
Before that, you cannot do in any case.
My lords will grant us liberty. My lord will correct or rectify if any there is wrong. My lord will.
But then we'll close this matter
my
by saying that on an assurance given that a formal
yes,
will
that
formally
that can be
served
recorded. My lords.
and prior notice will be served upon the officer asking him to show cause as express to why the inquiry report should not be
My
disagreed.
lords. He-
Only after such report is furnished, further action will be taken in the matter. We can close the
My lords,
petition with
I
that.
can assure that, my lord,
Right?
that he'll be supplied a copy.
At the face of it, this order will go, your lordship.
Huh?
This order would go.
Which order?
The impugn order, your lordship.
Impugn order is dated?
28/3/2025. Page 53 to 55. Last portion, page 53, whereas the disciplinary authority is not satisfied with the findings of the inquiry officer and accordingly is to the opinion the further inquiry needs to be conducted into the matter under the provisions of so and so. In view of the fact certain vital aspects so and so has been missed in the proceeding which needs to be properly dealt with by following due procedure and by according full opportunity dealing. Therefore, it is found essential expedient to continue further with the DP for a conclusive and logical conclusion. By taking into account the issue of additional charges, charge sheet by incorporating the fullest report and so. Where a prosecution section that has been there, your lordship.
So this order is also challenged in another writ petition.
Yes.
Only to the extent of placing me under suspension.
We have to get both together. Both the matters have to be a common order has to be passed. Because the same notification is partly under challenge in one writ petition, partly under challenge in this.
This writ petition only against issuance of order
Correct. So
inquiry.
the notification cannot be set aside partly. That's the law.
With your lordship. But
Notification can be set aside partly.
one,
What is there to leave it to the court? Can this notification?
your lordship please to say the other part.
No, then we'll tag it together day after tomorrow and dispose it off. Both the cases will dispose of. You have challenged the same notification in another writ petition. You say that there the suspension has been stayed. Here the further inquiry is under challenge. But ultimately, if the notification has to be quashed, it cannot be quashed partly. Can a notification be quashed partly?
No,
So if I allow your prayer, I'll be allowing a writ petition which is not listed before the
this
court.
number four.
That's the simple thing I am saying. You are saying leave it to the court. Give me a suggestion how it can be done. Can it be done?
I being a junior, your lordship, I
You are
can give
junior?
a- No, your lord, not to your lordship.
Heard Miss B, we are learned junior
They
counsel.
have to, they have to.
You are wearing a
have to be
designated senior ground and
No, not a junior counsel, lordship. I'm being a counsel, lordship. I will not be.
you are a senior counsel.
I am. My lord.
Yes.
While lordship, I'm privileged. It's a lucky code for me. While lordship doing duty here, I got the seniorship.
My lord will fix it this in next week, my lord. I will be available.
Just a minute. Mr.
Lordship, I'll not be available tomorrow, my lord. So can it be 10:30 tomorrow, my lord? I'll get a positive order. If your lordship permits, I'll seek your lordship indulgence.
Well, I am traveling to Arunachal today.
Hmm?
After this matter, I am traveling to Arunachal, my lord. I have a matter fixed there, my lord.
Right. Heard Miss B, we are learned counsel for the writ petitioner. Senior counsel appearing for the writ petitioner. Also heard Mr. D. Gogoi, learned standing counsel for the Forest Department. The order dated 28/3/2025, by means of which a further inquiry has been directed against the writ petitioner in the departmental proceeding earlier initiated against him, has been assailed on the ground that although the inquiry report dated, what is the date of inquiry report? Earlier inquiry, what is the date?
22/10/2024.
22/10/2024 has exonerated the petitioner in respect of the charges brought against him. Yet, without furnishing a copy of the inquiry report and also giving any opportunity of hearing to the petitioner, the disciplinary authority has differed with the finding of the inquiry officer and directed further inquiry, which practically amounts to de novo inquiry. On such ground, the instant writ petition has been filed. First up, on instructions obtained, Mr. D. Gogoi, learned standing counsel for Forest Department, has submitted in his usual fairness that there was a necessity for the department to serve a copy of the inquiry report to the petitioner before differing with the findings of the findings recorded in the inquiry report dated, what is the date?
22/10/2024.
22/10/2024. Therefore, the said procedural formalities would now be adhered to by the department before proceeding any further in the matter. Mr. Gogoi has further assured this court that within 3 weeks, a copy of the inquiry report along with show cause notice will be served upon the petitioner, eliciting his response in the matter. In view of the above, issue notice of motion returnable on 21st of July 2025, since Mr. Gogoi has appeared and accepted notice for respond numbers.
All again?
Respond numbers?
All
the respondents?
Oh, here's for 3, my lord.
Respond numbers 1,
1, 2, 4, 5,
4,
6.
5 and 6. And Mr. R. Borpujari, learned standing counsel finance for respond number 3. Service of notice is deemed to be complete in this case. Extra copies of the writ petition requisited numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction. Office to list this case again along with WPC number 2027/2025, wherein the same notification is under challenge. Having regard to the submission made by Mr. Gogoi, learned departmental counsel, the authorities are permitted to go ahead go ahead with the matter insofar as serving of enquiry report and show cause notice upon the petitioner is concerned. However, no further action in the departmental proceeding will be initiated till the next date fixed.
On a small correction, if allowed, my lord. He is not been exonerated. Charges were partially established.
Acha, where he was exonerated with regard to some of the charges. Some of the charges.
Always.
Cool.
Item 7.
Please, Your Lordship. I want to submit only 4 points.
Only 4?
Yes.
Not many points. Can you make it 3?
No.
No.
Lordship,
Hmm.
after
Acha, number one, yes.
after issuing the office memorandum notification of 2024, this Honorable High Court already directed the respondent authority to consider all compassionate appointment on merit and to supply.
Okay, this is number 1. Number 2.
Second is, my application was covered by OM 2015. As per that OM,
Okay, number 3. Number 3. Number 3. Point number 3.
the respondent authority is liable to communicate of such order.
Number 4. What is number 4?
That is, my father was entrusted for his duty at NCL. And at that time, my father was inflicted malaria and accordingly died.
Died when? Died when? When?
2009.
Speak little louder.
2009. Leaving 4 minor children. That is annexure page number 24. 4 minor children. And immediately within 3 months, my mother had applied.
Yes, Mr. 4 points. Yes, strong.
Lordship, first one, Lordship, paragraphs 10 of the coordinate bench judgment, Lordship. It is stated that he stated that regarding he referred this judgment,
It
Lordship.
will not be a precedent. Yes, next.
Lordship. Number 2, Lordship, it is covered by the Devrata Tiwari case. Rest of his arguments.
Yes. Then 2,
Then
3, 4 covered by Devabrata Tiwari.
yes, Lordship. And this petition may be dismissed, Lordship.
Lordship, they have to be communicated the outcome of my application before this order. My application was for consideration and police verification also done.
Do one thing. We'll neither allow nor dismiss. We'll have it after vacation for motion. Okay. The request of Mr. Pramod, counsel for the petitioner, let this matter be listed for motion again after vacation. Let's see the weather will change after vacation. With the changed weather, you never know what is there in store.
This may be issued and directed to
After
outcome.
vacation. After vacation. Yes. Yes.
That is suspension without review. They will continue. Was suspended in 19/9/24. Is covered by Ajay Kumar Chaudhary.
Do you have an extra copy? Can you?
No, this is correct, Lordship. So cause I have also annexed a so reply also. But point is, this legal point is this Supreme Court already settled down the law
that Ajay Kumar Chaudhary's case, that suspension cannot be extended beyond 3 months. No review, nothing. Only this instruction will not purport. This instruction says nothing. Appointment, I also not present. I also not appointed. So this is the judgment of Ajay Kumar Chaudhary, Lordship.
So 19/9/2024, he was placed under suspension.
Yes.
And is there any order extending it?
No.
There is no extension.
Then how do you meet the law laid down in Ajay Kumar Chaudhary, and there is another
Ajit, that is true, but
what is it?
so far as Ajay Chaudhary is concerned, Ajit, para 22 is relevant. Considering para 22, another judgment also passed by Honorable Supreme Court, Ajit. May I read para 22. So far as the facts of the present case are concerned, that appellant has now been served with charge sheet, and therefore this direction may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondents will subject to judicial review. Considering
Charge sheet has been filed, yes.
Yes, this is also charge sheet has been filed.
No, my case is no charge sheet.
Yes, charge sheet.
I have given a reply thereafter.
Yes.
The Shokos is not charge sheet.
Shokos is not charge sheet. Shokos, I have submitted a reply, I have annexed of both the things.
Suppose notice.
Shokos is why disciplinary proceedings should not be initiated.
Page 10 is a Shokos notice. Page 14 my reply.
Along page 10 is Shokos notice. And 12 is statement of allegation. List of documents, list of witness, all are served. Page 13.
That is Shokos notice is not the charge sheet.
So where are the charges? What is the charge number 1? Can you read out, please?
Allegation 1, Lordship.
Statement of
Please let him answer.
Statement of allegation, page 12.
No. Statement of allegation. So there is no charge.
There is no
Statement of allegation is not charge.
Lordship, page 10, Lordship. You are hereby required to show cause under Rule 9 of the Assam Service and Disciplinary Rule as to why any of the penalties prescribed under clause so and so of the Atrocity Act should not be inflicted on the following charges.
What is the charge number 1? I'm asking you.
Yes. 1, 2, 3, 4. 1, 2, 3. That's it.
And which para of Ajay Chaudhary you want to rely?
22, Lordship.
Yes, what does it say?
In that case, the Lordship.
Para 22 of Ajay?
Yes, Lordship.
Yes.
So far as the facts of the present case is concerned, the appellant has now been served with charge sheet, and therefore this direction may not be relevant him. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondents will subject to judicial review. In that case, Lordship, charge sheet was filed, but since charge sheet has been filed, the Honorable Supreme Court did not interfere with the suspension of the Ajay Chaudhary. Following this principle, Lordship, another judgment was passed by the Honorable Supreme Court, that is year 2022 SC 168, Lordship. Paragraph 13, Lordship, facts. Paragraph 13. May I read?
Yes, please.
Say, so and so learned senior counsel appearing for the respondent number 1, on the contrary, would submit that respondent number 1 was appointed by the state government under section so and so, and post of AMC is perimeteria with that commissioner who is appointed under section 36 of MMC Act. He submitted that under section so and so is subject to the same liabilities, restriction, and terms of the condition of service to which the commissioner is subject to as per the provisions of MMC Act. He further submitted that the post of the commissioner and the AMC find place in chapter 10 of MMC Act, whereas section 56 finds place in chapter 4 of the MMC Act. He submitted that various other section of the chapter 4 of the MMC Act provides for appointment of various municipal officers and servants other than AMC commissioner, and therefore the terms of competent authority will have to be construed by only such authorities who were competent to make appointment to the post of found in chapter 4 of the MMC Act. He submitted that, it is relevant. In any case, in view of the judgment of the court, in the case of Ajay Kumar Chaudhary versus so and so, through its secretary so and so, continued suspension of respondent number 1 was not warranted. He submitted that even charge sheet was not submitted within 90 days, there is no reason to interfere with the impugned judgment. Then lordship, findings of the honorable court was from para 50. Insofar as prolonged suspension of the respondent number 1 is concerned, the respondent number 1 has realized judgment of this court in a case of Ajay Kumar Chaudhary and state of Tamil Nadu represented by secretary so and so, reported in 2018-17 SCC 677. Insofar as judgment of this court in the case of Ajay Kumar Chaudhary is concerned, though this court has deprecated the protected period of suspension and repeated renewal thereof, in the facts of the said case, this court found that since the appellant therein was served with charge sheet, the direction issued in the said case may not be relevant to him any longer. Insofar as the judgment of this court in the case of Pramod Kumar Chopra is concerned, this court observed that there cannot be any dispute regarding power or jurisdiction of the state government or continuing the first respondent under suspension pending criminal trial. There is no doubt that allegations made against the first respondents are serious in nature. However, the point is whether continued suspension of the respondent for a prolonged period is justified. In the said case, the respondent number 1 therein was suspended for more than 6 years. This court found that no useful purpose would be served by continuing the respondent number 1 therein under suspension any longer. We find that in the present case, it is the respondent number 1 who, though called upon to participate in the department proceeding, has on his own chosen not to participate therein. It is the respondent number who had objected to the initiation of the department proceeding by the commissioner on the ground of judicial jurisdiction and refused to participate in the department proceeding. We therefore find that the respondent number 1 cannot be permitted to take benefit of his own wrong. In any case, that is important, Lordship. In any case, we find that the issue of prolonged suspension would be taken care by the directing the departmental proceeding to be completed within a stipulated period, but the suspension of respondent number 1 would continue till then. We find that the judgment passed by the Honorable High Court is not sustainable in any law. In result, the appeals are allowed in the following terms. The impugned judgment dated so and so passed by so and so is quashed and set aside. Writ petition so and so is dismissed. The departmental proceeding initiated against the respondent number 1 are directed to be completed as expeditiously as possible, and in any case within a period of 4 months from the date of judgment. Respondent number 1 would continue to be under suspension till the conclusion of the said departmental proceeding, pending application, if any, stand disposed of in the above terms. My submission is that since charge sheet has been issued, Lordship, and DP is initiated, in the timely manner, Lordship, respondent may be directed to conclude the DP. In terms of this judgment.
Let us dispose of this by saying that within that period they have said conclude it, failing which they will revoke the suspension and reinstate it. This is option number. This is option number 1. If you agree to that, that order can be passed. Otherwise, otherwise we'll have to issue notice and answer this plea. That cannot be done in the motion stage. Then you have to wait, because See,
My
these
submission-
judgments cannot be used like mechanical.
No, that it doesn't. But my case is Lordship is distinguished from that because here only so-called notice issued. I have submitted my reply. So prolonged suspension is continued. So as far as here submission that search is not in ministry, no review. That is my case, Lordship. Now Lordship to decide.
All right, charge sheet is a suit. This is charge sheet.
No,
Yes, this is charge sheet.
so-called is.
Yes, there are charges here.
No.
You please read it.
No,
These are
charges, so-called charges.
This amounts to serious
Yes,
negligence in the
I've
conduct of duty.
I've given the reply, Lordship, kindly.
Correct.
Kindly see the reply, page 15, the one by my reply.
Yes. No, charge sheet is there. This is charge sheet.
This is charge sheet.
So question is, once charge sheet is submitted,
Lordship.
and it is not a case of huge delay because your client has been suspended only in September last year. So if the department says we'll conclude it within 30 days.
3 months.
Within 3 months. Within 3 months. Are they not entitled to that?
Yes.
That answer we have to give it.
Yes, within 3 months, let them complete.
Are we agreeable to
Yes,
that?
because on that part, because I am ready to face the trial. So inquiry will be completed and it is the procedure, the inquiry must be there.
Then we'll close it by saying that
By limited period, within 3 months.
within 3 months.
What?
Within 3 months with effect from
Date?
within 3 months with effect from that is your own within 3 months from when?
From the date of receipt of certified copy, Lordship.
Huh?
From the date of receipt of the certified copy, Lordship.
That we can give this order.
Lordship.
All right. I heard Mr. H. Raman and his senior counsel stated by Mr. Swanson and counsel appearing for the petitioner. Also heard Mr. S. Dattal and its standing counsel, Revenue Department, Assam, as well as Mr. J.K. Gosin, learned additional senior government advocate, Assam, appearing for the official respondents. The read petitioner, while serving as sub-register in the at Obhayapuri in Bongaigaon district, was placed under suspension by order dated 19/9/2024. Full stop. A SOCO's notice containing the charges as well as the statement of allegation was served upon him on 3/1/2025. The petitioner has also submitted his response, his SOCO's reply to the charges brought against him on 29th of January 2025. Full stop. The departmental proceeding so initiated against the petitioner is pending before the authorities. However, contending that within the period of 90 days from the issuance of the order of suspension dated 19/9/2024, the disciplinary authority has neither reviewed the said order nor extending the same by furnishing proper reason. As such, the order of suspension has lost its force in the eye of law. The learned senior counsel for the petitioner, by relying upon the law laid down in the case of Ajay Kumar Chaudhary versus Union of India, etc., 2015 so and so, as well as the judgment of this court rendered in the case of State of Assam and others, another versus Ajit Sanwal and others, reported in 2023, (6) GLT 115, has submitted that the present is a preeminently fit case where the order of suspension be set aside and the petitioner be directed to be reinstated in service. Full stop. Mr. Rahman has also submitted that his client would face the departmental proceeding by rendering all cooperation if need be. Therefore, there is no necessity for the authorities to keep him under suspension for any further period. Full stop. In terms of the order date, next para, 16/6/2025, in terms of the order dated 16/6/2025, passed by this court, Mr. S. Dattal and his standing counsel for the Revenue Department has obtained written instruction dated 18/6/2024 and placed the same before the court. As per the instruction obtained by Mr. Datta, it appears that the departmental authorities have given an assurance that they would conclude the departmental proceeding within 3 months. By referring to and relying upon the recent decision of the Supreme Court rendered in the case of Kalyan Dombiveli Municipal Corporation versus Sanjay Gajanan Gharat and another. Mr. Datta has further submitted that when charge sheet is submitted against the delinquent, the order of the continuance of the order of suspension would have to be assessed on the basis of facts and circumstances of each case, and to that extent, the decision rendered in the case of Ajay Kumar Chaudhary bracket Supra would not be of any assistance to the petitioner. I have considered the submissions made at the bar and have gone through the materials available on record. It is no doubt correct that the authorities have not reviewed and that we got passed a specific order of extension of the period of suspension of the petitioner within 90 days from the date of issuance of the order dated order dated 18/9/2024. However, it is also equally true that within 19/9, not 89, that on 3/1/2025 itself, charge sheet, a memorandum of charge was submitted, was served upon the petitioner, thus initiating disciplinary proceeding against him. Therefore, it is not a case where the departmental authorities had continued with the order of suspension without having any real intention of proceeding against the petitioner with regard to the charges sought to be pressed against him. The ratio, a careful analysis of the ratio laid down on the case of Ajay Kumar Chaudhary Supra and Ajit Sanwal Supra goes to show that the basic idea in those cases was to put a halt on the practice, a halt in the practice on the part of the department to keep the delinquent officers under prolonged suspension without initiating any departmental proceeding against them, thus not only causing prejudice to the interest of the employee, but also depriving the department itself from the benefit of service of the said employee for prolonged period. Whether an order of suspension can be interfered with merely because the period of 90 days has expired before a review was conducted in respect thereof, when the disciplinary authority had served charge memo on the employee, is a matter which would undoubtedly come within the facts and with the ambit of facts and circumstances of each case, and no straitjacket formula in respect thereof can be laid down. The decision rendered in the case of Ajay Chaudhary Supra and Ajit Sanwal Supra, in the opinion of this court, does not lay down the proposition of law that even in cases where charge sheet is submitted, an order of suspension cannot be continued beyond the period of 90 days. At this stage, Mr. Rahman has fairly submitted that 90 days. Therefore, the matter would require further examination. However, at this stage, Mr. Rahman has submitted that he would have no objection if the writ petition is disposed of at the stage of motion hearing by directing the respondents to conclude the departmental proceeding within 30 days within 3 months, from the date of receipt of a certified copy of this order. The learned Departmental Council has also agreed to such an order. In view of the above, without delving any further on the contentious issues involved in this proceeding, the present writ petition is disposed of by providing that within 3 months from the date of receipt of a certified copy of this order, the departmental proceeding so initiated against the petitioner shall be brought to its logical conclusion by passing final order as may be permissible under the law. Full stop. If the authorities fail to conclude the proceeding within 3 months, the petitioner would be liable to, would be entitled to seek reinstatement in service. Full stop. Reinstatement in service on the expiry of the period of 3 months. Full stop. With the above observation, the writ petition stands disposed of.
Objection.
In this matter, Mr. K. Chaudhary, Senior Counsel, would like to assist your lordship. Today, he has some personal difficulty. Can it be taken up next week?
Next week. When do you want it?
Wednesday. Okay.
Next Wednesday.
Yes.
All right, all right. You are doing fine. Low on confidence, is it?
The petitioner wants.
Acha, acha. On the request of Mr. J. Patwari, learned counsel for the petitioner, made with the consent of the other side. This case for motion again on, what is the date on Wednesday?
25th.
25th of June 2025 for motion. Mr. B. Gogoi, learned additional AG, bracket health, bracket to Assam is present on behalf of the respondents.
For admission, I can 18.
Here I need some other time, lordship, to get the proper instruction, lordship. In fact, lordship, the petitioner was a employee of lordship, mechanical division. This is not non-existent, lordship, now, lordship. So I need some accommodation, lordship, to get the proper instruction, lordship. His account regarding his GPF amount.
But this is an old matter.
Old matter, lordship, but this matter was only listed second time on last occasion, lordship. I'm sorry. Get away, lordship.
No, but how much time can you ask for?
1 week, lordship. 1 week, lordship.
My pleasure lordship, 1 week may not be sufficient because it is pending for a long time. There are two issues. One is GPF. They continue to deduct GPF, and when he was regularized, you are telling them, no, you are not under 1969 scheme. So there should be GPF and NPF. So some amount is credited to NPS account, and the earlier the money was credited to GPF account. So these both accounts, it may be around 3 to 4 lakhs, my lord. So 1 week, my friend is telling 1 week, but
He's suggesting me to take 3 weeks.
Let them 2 weeks. Let them 3 weeks. One more thing, my lord, if you kindly allow me to say, because there is a deduction, the poor fellow, there is a deduction of 100 rupees per month about the group insurance. Since he is being considered under this normal scheme of 1969, he is eligible for everything. This gratuity he got, pension he is getting, but this Provident Fund, GPF, and the subsequent credit to NPS. The combination of this GPF and these things, and plus group insurance also, if it is possible, because there is no cooperation from the official. This poor fellow, old and suffering, is commuting. Now this, previously it was in Konapur area. Now the office has also been shifted.
So is it that you are not taking old things seriously?
No, lordship, not the last date, lordship.
Old case, old pensioner, you are not.
In fact, lordship,
My lord, I'm sorry to say, nothing is happening, only when my lord and this honorable court intervene, then only something is coming out. This is the reality of life today.
All right, we'll give him some reasonable time, but it'll come with a rider.
Lordship.
I heard Mr. G.R. Dev, learned counsel for the writ petitioner. Also heard Mr. N. Upadhyay, learned standing counsel for Irrigation Department, Assam, who has once again submitted that this being a very old matter, 4 weeks further time is required for him to obtain concrete instruction, as the department in which the petitioner was serving is no longer in existence. Appreciating the difficulty expressed by Mr. Upadhyay, time is granted to him till 30th of July 2024 so as to obtain instruction and file affidavit placing on record the response of the department with regard to the plea raised in the writ petition. Full stop. It is made clear that if no affidavit is filed on or before the next date fixed, this court will consider passing consequential order besides addressing the issue raised in the writ petition on merit without the affidavit. Mr. R.K. Talukdar, learned standing counsel for the office AGANE Assam, is present on behalf of respondent number 7.
Actually, nonetheless, to make small prayer. In the earlier matter, item 23, can the date be changed to 24 instead of 25?
24.
Right. Deeply.
24/4 is more auspicious.
No, my lord, from 23 onwards, since I will not be available. Deeply.
May I please, Your Lordship? Lordship, here we have received the pension proposal from the department, Your Lordship. So it is under consideration. Scrutiny is going on, Your Lordship. And I asked verbally that how long it will take. They said that it will be after completion of scrutiny, Your Lordship. It will be within 2 weeks. They will issue the PPO.
Let them process it. Heard Mr. H. Talukdar and counsel for the petitioner. Also heard Mr. R.K. Boro.
R. Boro,
learned standing counsel AGANE Assam, appearing for the respondent number
5.
5, who submits that a pension proposal for the petitioner has been received from the department, which is under scrutiny. And there is every possibility that within 4 weeks from today, the matter will be resolved. On such ground, Mr. Boro has sought posting of this case again after 6 weeks. Ms. S. Campbell, and standing counsel for KSE, is present on behalf of the official respondents. On the request of learned counsel for the respondents, let this matter be listed again after 6 weeks as a fixed item. In the meantime, the pension proposal be processed and a final decision be taken in the matter.
Oblige.
Will kindly see at page 80, para 7 of the order of this court. Page 80, para 7.
Yes.
Just one paragraph. In the letter dated 28/2024 of the DC Sarai, it has been conveyed, since the petitioner being a Gaon Pradhan is a public servant, there is necessary to inquire into the allegation against him internally before initiation of any departmental proceeding. It appears from the sale of 2 proceedings initiated against the petitioner and few others in respect allegation with a complaint submitted by so and so regarding illegal mutation respect to aforesaid mentioned 2 plots of land. These 2 proceedings are not departmental proceedings and inquiries into the complaint of same nature. In such view of the matter, the court is of the considered view that it would be expedient for the purpose of considering to avoid the possibility of passing the conflicting orders in 2 different proceedings in respect to the same subject matter. The DC shall get both the complaint inquired by one authority, that is either by himself or by any authority under his superintendent, as the case may, for expeditious consideration of such proceeding. Petitioner has to answer his participant in such proceeding, and for the purpose, the judicial district or the authority who will entrusted to conduct the inquiry shall serve due notice of petitioner for the appearance. It therefore directed, after taking a decision for consolidation of the proceeding, petitioner should be duly intimated about the date of hearing of the proceeding. So, this is not a departmental proceeding. Before initiation, they have to do it. Now, when the matter was moved before this honorable court on 3/10/2024, we sought for stay of paragraph at page 81. They have placed under suspension, my lord, at page 81. But the court said, no, let us wait, see what is their response by filing the records. Now, they have filed a response to it. An affidavit has been filed. it appears that para 7 has not been complied. And on the basis of page 81, at page 82, they have issued a show cause. But the court's order was very clear that this is not a departmental proceeding. Internal inquiry should be made first. But that has not been done. And that is apparent from their affidavit. We have taken a specific stand at para 26 of a writ petition. Para 26 and the reply is apparent. They have not done anything to give a notice to me. So they cannot, in view of para 7, there is no question of a departmental proceeding and placing me under suspension. That's my case, my lord. That is why your lordship, on the first occasion, your lordship said, you wait. We will see what the response comes on 3/10/2024. Now the response is very clear. They did not comply the court's order at paragraph 7. That's the whole case, my lord.
No, but now what you are seeking here?
I am seeking that they should comply with the court's para 7 and 81 and 82 should go. Where is the question of placing me a suspension departmental proceeding? They can't do it. First, an internal inquiry has to be made. They have to.
But the court doesn't say before the internal inquiry you cannot pass any.
No, that's what. Kindly see, my lord. No. So I just read it. Para 7.
Yeah.
In the letter dated of so and so, it has been conveyed, since the petitioner being a Gaon Pradhan is a public servant, there is necessary to inquire into allegation against him internally before initiation of a departmental proceeding. It appears from the said letter that 2 proceedings initiated against the petitioner are in respect allegation made in the complaint submitted by Srimati Sulema Khatun regarding illegal mutation respect to the aforementioned 2 plots of land. The 2 proceedings are not departmental proceedings. This is what, and are inquiries into a complaint of same nature. In such view of the matter, the court is of the considered view that it would be expedient for the purposes of consistency and to avoid the possibility of passing of a conflicting orders in the 2 different proceedings in respect of the same subject matter, district commissioner shall get both the complaints inquired into by one authority, that is either by himself or by any authority under his superintendence, as the case may be. For expeditious consideration of such proceeding, petitioner has to ensure his participation in the said proceeding, and for the purposes, the judicial district commissioner or the authority will be entrusted to conduct the inquiry, shall serve due notice to a petitioner for his appearance. It is therefore directed, after taking a decision for consolidation of the proceeding, petitioner should be duly intimated about the date of hearing for his participation in the proceeding. Now, what are those proceedings? Those proceedings, a notice has been issued. Initially, if your lordship looks into it, that proceeding is at page 29.
29.
29 is the notice which has been issued to us, because there were 29. See at page 29, man. This was a notice which was issued on 25/5/2023. They said that issued by circle officer for complaint against mutation. Lordship got it? Now there is a reply which has been filed at page 33 by us. 33. This is a written objection filed before the circle office on the basis of a notice at page 33. See page 33, man.
Yes.
This is a written objection filed by us against that notice. Right, my lord? Now, in the meantime...
Right, so, you are seeking disposal of the writ petition.
No, that's what I am saying, my lord. This apparently, it appears, a suit was also being filed. My lord, my argument before this court is that these are the notice which you have served. It was before different forums like SDC, Circle Officer, ADC. So we moved the matter before the court. Initially, there was a writ petition. We said you did not serve a complaint to us about the complainant which has been illegal mutation. They served the copy. Then, my lord, it was disposed of. Thereafter, we filed another writ petition saying it is before different forum, Circle of ADC. Now the court, the matter has been taken up by the court, and finally at page 80, para 7, the court said yes, all this notice which has been issued, it will be by one, either by deputy commissioner or by any of his subordinate on the observation by the DC, and you have to give a proper notice to him. Without conclusion of that internal inquiry, my submission is that how can you place me under suspension? This is my case, my lord. Before conclusion of the internal inquiry, this was directed by the court to proceed and give a chance to
That's
me.
I have understood, but is there any observation that before this inquiry is concluded,
No,
no further
that,
action?
my lord, this is implied. My lord, kindly see if I am not wrong. At para 7, this is implied, my lord. Kindly see.
Why have you placed him under suspension?
Lordship, eh, uh, here in this case, Lordship, so far in my affidavit I placed before this honorable court is that, Lordship. Before that, I would like to submit, Lordship.
Do you know what the case is?
Yes,
Because
Lordship.
now you are going to read the.
They challenge against the suspension, Lordship. Now we have a rule, Lordship. Rule 162. They may go for appeal, Lordship. Without going to the appeal, Lordship, they directly come before this honorable court, Lordship. Now there has an alternative proceeding, which is a mandatory appeal is there, Lordship. Lordship, they may file the appeal, Lordship, under 162.
Different things. You tell us what action has been taken as per the order, para 7 of the earlier order dated 1/3/2024.
Lordship, paragraph 14 in my affidavit, Lordship. The basis of the complaint petition submitted by by Suleiman Khatun and the inquiry report submitted by the circle officer Sunari. It means inquiry report, preliminary inquiry was done by the circle officer, Lordship. Sunari, Revenue Circle, dated 19/7/2023. The notice dated 2/01/2014 and 7/3/2024, Lordship, were issued by the sub-divisional officer, Lordship. One inquiry was done, Lordship, by the circle officer. On the basis of that inquiry.
But was it completed? What is the outcome of that inquiry?
No, the preliminary inquiry, so far in paragraph 7 of the earlier order, Lordship, a preliminary inquiry was done.
Yes, but that has been concluded.
No, the preliminary inquiry after obtaining the findings of the preliminary inquiry, the present the circle officer issued a show cause notice. Lordship, the sub-divisional officer Sodor Sunari issued a show cause notice.
Mr. Das, this matter will require a little hearing.
Yes, Lordship.
Can you suggest a date when we can hear?
It's convenient. Whichever is convenient.
Your convenience.
Whichever. 26th, oh no, this is just for vacation. After vacation, whichever.
After vacation. Any date convenient to you?
Not commencing immediately after the reopening, after 14. Not after 14. It was.
Would you like to have it on 22nd July?
22nd, yes, Tuesday. 22nd.
Right, I had Mr. Didas, Lani Senior Counsel, assisted by Ekiro Namtulibo. Also had Mr. J.K. Osami, Lani Additional Senior Government Advocate Assam, and Mr. S. Datta, Lani Standing Counsel, Revenue Department, appearing for the respondent. It is submitted at the bar that pleadings have been exchanged, and having regard to the nature of dispute involved in this proceeding, the writ petition can be finally disposed of at the admission stage. In view of the above, and as requested by the petitioner's counsel, list this case for admission hearing as a fixed item on 22/7/2025. An attempt will be made to dispose of the writ petition at the stage of admission hearing.
Declare. Declare.
But this is an old matter regarding the pension. I'd like to draw your lordship attention on the order dated 4/4/24.
4/4/24. Yes. Hmm. Code 24. Code 4/24 court order.
Yes, court order.
Yes, yes. Yes.
Then 5/2/24, lordship, just 5/2/25. all the time misleading the court. That is why I am drawing lordship attention. Issue is something else. They are diverting the issue to something else. 4-4, then 5-2. 5-25.
Yes, I understand, but
Then thereafter, 11-6 again.
but what is to be done? Our final hearing will not be possible.
No. Lordship, my prayer is because it is pending from 19, Lordship. So if the pension case is dragged like this, so how people will come to the court for justice? Tell me, Lordship suggest me. From 19 onwards, it is 25. Some people died also.
No, it should be heard next week.
Any date, Lordship,
Yes.
but it should be finally disposed of.
Yes. But it has to go to some other bench because I cannot hear the matter now. Hearing is not possible. You understand the situation. I would have loved to, but there are some norms which we have to follow. Would you like to have it in some other bench?
Any bench, because it is not privilege that I am doing this bench. It is not my practice since last 35.
No, I understand.
35
So what is
years
the
I am
matter?
practicing
Why are you not coming out clean?
No, Lordship, so far, Lordship, regarding the pension, Lordship, first we have to decide whether they are able to get the pension or not.
Heard Mr. H. Raman, Senior Counsel appearing for the writ petitioner. Also heard Mr. J.K. Goswami, learned Additional Senior Government Advocate Assam, and Mr. R. Bopachari, learned Standing Counsel Finance, appearing for the official respondents. Mr. Mr. So-and-so, learned Counsel. Mr. S.C. Khan, learned Counsel, is present on behalf of the respondent number 8. Mr. Rahman submits that despite repeated opportunities granted by the court, the department, the respondents have not come clean with their stand.
Neither they have produced record because record
Vis-a-vis the claim made in the writ petitioner, nor have they produced the relevant records. Under such circumstances,
nor the affidavit with specific inquiry by the honorable.
The writ petition deserves to be heard and disposed of on merit without any further delay, as his clients are
all retired persons.
All retired persons who are waiting for the pensionary benefits. Full stop. Taking note of the submission of Mr. Rahman and and as agreed to by learned Departmental Counsel, list this case for admission hearing as a fixed item on 24th of June 2025. An attempt would be made to finally dispose of the writ petition at the stage of admission hearing. That's all.